speaker, I would pose the question, what difference do a bunch of judges make to those who plan war and repression? Do we really think that Saddam Hussein would quit before gassing Kurdish villages? Do we think that these judges would deter the organizers of the Rwandan genocide? No, we do not, ladies and gentlemen. Today, we are dealing with some of the most atrocious aspects of humanity. Crimes, very serious crimes, like genocide, war crimes, and crimes against humanity. The torture, extermination, and annihilation of a people, ladies and gentlemen. Crimes where fundamental and basic human rights are being blatantly violated. Setting up mechanisms to deal with these atrocities is beyond desirable, ladies and gentlemen. It is something that we all want. But today, we must look beyond mere optimism and look at the way things are today. The idea of setting up a court with jurisdiction over these kinds of crimes is not new, but recently has become an issue again. The tribunals in Yugoslavia and Rwanda are the precedents for this international court. These crimes call us to action, and we must do something. But the way that things are set out today, this action, this means of dealing with these crimes, is ineffective. The International Criminal Court will not work, ladies and gentlemen. Now, of course, by International Criminal Court, we are referring to the body established and governed by the Rome Statute that was signed in June of 1998. And by will not work, won't work, we mean that it will not be able to efficiently achieve its objectives. And what are these objectives? First, the deterrence of genocide, war crimes, and crimes against humanity, and a fair trial and punishment for those individuals responsible for these crimes. Today, we must bear in mind that the desirability for the International Criminal Court to work is beyond question. We wish to prevent these crimes. We would like to see these crimes never happen again. However, the way the court is set up today, this just won't happen. Now, today the government will prove that the International Criminal Court will not work on two counts. First, that it adopts a standard legal procedure. And this legal procedure, in principle, this standard method for dealing with these crimes is an inefficient way to deter them. And two, that even in terms of punishment, the International Criminal Court is too weak to effectively punish the perpetrators. And we believe this because of three things. First, that this court does not have everybody under its authority and jurisdiction. Second, that it is not impartial, and it is plagued with political interference, no thank you, which does not allow justice to be exacted. And finally, that it does not have the muscle it needs to enforce its decisions. And what do we mean by muscle? By muscle, we are talking about an independent means to force criminals to respect the decisions of the International Criminal Court. The objective of any court, ladies and gentlemen, is to deter and punish criminals. And none of these principles are being provided for by the International Court. Now, I will deal with the problem of deterrence and the problem of the jurisdiction of the court. And our second speaker will complete the case for the government, saying why the International Court is partial and is plagued with international and political interference. And also why the fact that it does not have a way to enforce its decisions leads to the court being ineffective. There is no effective provision to deter and punish these crimes by the current statute for the International Criminal Court. Now, the crimes that the court must deal with occur in extreme situations. Crimes of people that are fanatics, that institutionalize hatred, annihilate cultures, and systematically exterminate people. They are denying other people their humanity and are violating fundamental human rights. And in the case of a fanatic, we see that they will not be stopped by the law. The very definition of a fanatic is that a person is irrational, does not see the law as something to be upheld. Their cause becomes the law. Yes, please.
What about despots and mad dictators, sir? The court could actually deter crimes by such people.
I'm glad that the opposition brought up this point, because I will get on to explaining why the court cannot stop dictators and cannot punish them. I will get on to that in just a few minutes. Now, in these situations, An uncertain and far-away punishment does not stop systematic hatred from coming into place. It does not deter these criminals, because the very definition of people who commit these crimes is that they are not rational. They don't see the law as something to be upheld. In these extreme cases, as are all the cases that the International Criminal Court must deal with, rational, positive law is not a deterrent. No, thank you. It will not stop a psychopath from killing off a whole culture. Positive, rational law is not an issue for the psychopath. As I said before, a vague and far-off punishment is not an issue in the minds of criminals. If they were rational, they would not be considering these crimes in the first place. Their cause itself becomes the law that they uphold. Again, what difference do a bunch of far-off judges make to the Serbians, for example, who seek to cleanse their homeland of Bosnians and Croats? None whatsoever. So even now, while the tribunal in Yugoslavia seeks to prosecute the leaders like Mladic and Karadzic, no thank you, people are still being slaughtered. Positive, rational law does not act as a deterrent, because rational law means nothing to these people.
Point of information,
no,
sir.
thank you. In these cases, we are trying to stop a system by means of an uncertain and far-off threat to an individual, without a way to enforce it, ladies and gentlemen. The only way to stop a genocide is to use force. And this is another one of the fundamental problems that faces the International Criminal Court. Only a physical threat, some way to enforce the court's decisions, will make a difference. And my second speaker will go on to develop this. No, thank you. Why? My second speaker will want to say why not having an armed force, not having some means of enforcing its decisions is a problem, and will not let it achieve its objectives and function properly. Now, the International Criminal Court, even in the manner that it is conceived today, is a useless and ineffective means for deterring crimes. No, thank you. And in terms of punishment, it is also ineffective. First of all, signing the treaty is optional. The ICC may only initiate procedures against nationals of signatory countries and crimes that occur in signatory nations. Furthermore, some countries voted against the International Criminal Court, thus removing them from the jurisdiction. Countries like the United States, who wish to protect their troops. Countries like Iraq, Libya, and China, who commit these crimes as a part of their everyday policy. These people, if they do not sign the treaty, we would be not allowing justice to be exacted where it is most needed. The International Criminal Court would not have jurisdiction where it is needed the most. This court will need the permission of criminals themselves to face trial. And this we cannot condone. This is why the International Criminal Court will not be effective, ladies and gentlemen. There is no provision to prosecute criminals there is a provision to prosecute criminals in non-signatory countries, but this would involve a unanimous decision on the part of the Security Council, and ladies and gentlemen, in the Security Council, the interests and geopolitical considerations of these countries come into play. A member of the Security Council will not let the court initiate procedures against one of their allies. And because the International Criminal Court has severe structural and organizational problems, because it will adopt a standard legal procedure to deal with these criminals, which is ineffective because of the exceptional nature of these crimes and the inability of rational positive law to deter these criminals unless there is a use of force. The International Criminal Court will be unable to adequately punish these criminals because it is so easy to escape the court's jurisdiction. There is simply no effective provisions to deter and punish these atrocious crimes by means of the International Criminal Court. Thank you.
Ladies and gentlemen, a very good morning. Now let us first examine the contentions raised by the proposition today. The first of which being the fallacious assumption, ladies and gentlemen, that everyone today is a fanatics. All the leaders in the world today who commit crimes against humanity are actually fanatics and psychopaths. They are all irrational. Now, ladies and gentlemen, we see here the affirmative being very extreme, ladies and gentlemen, in their false assumption. Ladies and gentlemen, I could quote to you people like Muammar Gaddafi, Sani Abacha. Ladies and gentlemen, these leaders are corrupt. They are power hungry. But ladies and gentlemen, they have full capacity of their mental faculties. They know very well what exactly it is they are doing. And therefore, we can clearly see that dictators and despots do not equal fanatics today. And also, furthermore, ladies and gentlemen, by trying to paint everyone who commits crimes against humanity as a mad, irrational fanatic, ladies and gentlemen, they haven't exactly proven to us why the ICC still won't work. They haven't managed to prove to us why, ladies and gentlemen, the ICC might not deter such people. Now, ladies and gentlemen, the next flaw on that side of the house was the manner in which they expected the court today to be a panacea for all crimes. Now, why do I say this? They tell us that the ICC has no brute muscle force. Now, exactly what are they expecting the ICC to be? A standing army? No, ladies and gentlemen, we have to understand the aims of the ICC. It is a judicial court responsible for passing out judgment, for carrying out fair trials, ladies and gentlemen. Not, ladies and gentlemen, to go and apprehend each and every single criminal in the world, not to go forcefully into a country as an army to stop the war. And ladies and gentlemen, no sir, we can further see how they expect the ICC to be a panacea when they tell us that it will not stop the situation in Serbia. The Serbians will still be slaughtered. But ladies and gentlemen, the court is not intended to stop each and every crime in the world all at once. What it's intended to do is to deter these criminals, and the negative today will show you in our substantive cases that it will indeed succeed in doing so. Now, next, ladies and gentlemen, they tell us that non-signatory countries cannot actually be targeted, and therefore the ICC is doomed to failure. Now, ladies and gentlemen, they went on to make a concession saying that, oh, actually, they can prosecute those non-signatory countries if the UN Secretary Council referrals agree on this. Well, ladies and gentlemen, a concession on that side of the house. However, they tell us that this means that vested interests come into play. However, let's just take this into account. When 5 members of the Security Council are actually all required to vote in order to prosecute a country, this means a lack of vested interest can take place, where one country cannot merely say, ladies and gentlemen, one country cannot merely say, I want to prosecute another country. We see it takes all 5 members, and this therefore acts as a check and balance. No, sir. And therefore, having examined the contentions that the affirmative today has raised and proven them to be false and fallacious, what shall we as the negative argue? Now today, we have to understand that the underlying element that the ICC requires, even before we can discuss its dual function, is global will. Now this global consensus and commitment is seen in the way countries have increasingly voiced their support for the court, from first the Geneva Conventions to the Rwandan and ex-Yugoslavian war crime tribunals, all the way up to the present ICC. 120 countries have voted in favor for the ICC treaty without reservations, and this is a 94% approval rate. Now, having established this, more importantly, a viable framework is necessary in order for the court to work. And therefore, as a negative, we will prove to you that the court does indeed have a viable framework in terms of its comprehensive scope, as I will show, and secondly, its checks and balances, as our second speaker will show. Our third speaker will further our case, and as a team, we will prove that because of its viable framework, this House believes the International Criminal Court will work. Now, moving then into my substantive case, where I will show that the scope of the ICC is comprehensive in that, firstly, it targets the root of the problem, and secondly, it makes provisions for future eventualities, and as such, it will indeed work. Now, on my first point then, on how it actually targets the root of the problem, we first have to understand the chain of command argument. And this means that the responsibility of a war crime, for instance, can be pushed up from the soldier who carried out the physical antagonization all the way up to the commander who issued the order for the crime to be committed. And this line of self-defense was actually disallowed in the earlier Nuremberg trials. Now, however, the ICC has made provisions for this defensive argument in Article 33 of the Rome Statute, and this translates into greater willingness on the parts of witnesses to step forward and testify. And as such, the court will function more smoothly in its court procedures, unlike, for instance, the Rwandan Criminal Tribunal, where UN prosecutors tried to indict almost every other person, and the whole situation disintegrated into a complicated farcical mess. Yes, sir.
Precisely, the court is working like the Rwandan tribunal, which has 130,000 cases pending.
Yes, exactly, sir. So in order to lessen the confusion this time, what they are going for is the key criminals, ladies and gentlemen, the ones who actually perpetrate the crime. And this means, ladies and gentlemen, they are breaking it where it counts and actually sending deterrent signals to leaders who may or who do commit such crimes. And this global need for deterrence and visible punishment for criminals is actually established in the preamble of the Rome Statute, showing that countries do indeed recognize the importance of an ICC. ICC. And thus, because the court's viable framework consists of a comprehensive scope which allows for the targeting of the root problem, it will indeed work. Now, moving then into my second point on how the ICC actually makes provisions for future eventualities. Now, we must understand that for the court today to work, it cannot go off on its own steam and make laws as it pleases. Rather, the real-world situation where national sovereignty is a sensitive and major issue has to be factored in. And here we see that by making allowances for issues such as the need for national security and fundamental law, the ICC Charter clauses work in tandem with national interests to achieve the ultimate aim of world justice. And this is why 120 countries have voted in favor for it. Now, in fact, by striking this delicate balance, it leaves no excuse for non-cooperation with the court, giving the ICC the exercise of power. Yes, madam?
Many countries have signed it, but not the main offenders of these crimes.
No, madam. What you don't understand is that you cannot expect each and everything to be done at once. Just like in the similar way, you cannot expect ratification and the beginning of the ICC to work at once. What you have to understand that this is a fundamental step, ladies and gentlemen, and that furthermore, other countries will be deterred, which is a key element of the ICC and one of its main aims. Now, for instance, Article 124 allows for transitional provision where countries may declare only once to opt out of the jurisdiction of the court for 7 years. Now, this gives countries the time to reconstruct order within their own national boundaries, like, for instance, Nigeria. Such practical considerations reassure countries which worry about national security violations, and this gives the ICC the exercise of power to deter crimes against humanity. And this principle also applies to the complementarity clause, which means that national criminal jurisdictions take precedence over the ICC prosecutions, and the consideration for sovereignty again gives states no room to willfully deny the court, and this comprehensive scope of the ICC ensures it was work. Now, ladies and gentlemen, at the end of my substantive, I have established that the comprehensive scope of the ICC targets the root problem and provides for future eventualities. And therefore, as a team, we will prove that because the court has such a viable framework, it will indeed work.
Members of the House, we have a serious problem nowadays in humanity. We have wars against, crimes against humanity. We have war crimes, we have genocide. And these are all crimes that have to be stopped, and have to be stopped now. And in order for us to do this, we have to create a system, we have to create a body that will work. We cannot create somebody that will say that it will create deterrent and it will punish effectively the people who commit these crimes when actually it does not. Because this is a dangerous thing to do. We would be creating a body that would be giving us assurance that we would be doing something, so we would be trusting that body to take care of these very dangerous issues when actually it would not be doing anything at all. It would just be allowing for these crimes to go on and on. And ladies and gentlemen, the fact that this criminal court will not work is because it does not address the nature of the crimes that it is trying to combat adequately. Because yes, the people who commit crimes against humanity, the people who commit genocide and war crimes are fanatics. No normal person would rationally believe that they can have the right to kill people in the most atrocious ways or get rid of a whole race.
Madam.
Yes, please.
You are arguing against the very principle of any judicial system and not the International Criminal Court.
Excuse me?
I'm afraid you are arguing against any legal system which tries to bring criminals to justice and not the ICC per se.
What I'm arguing is that the ICC has set distinct goals. It has to deter these crimes and it has to punish the people who commit these crimes. It cannot deter these crimes because there is no real way of deterring them, because these people are fanatics and cannot be deterred. The only thing that we could do is stop them, and to stop them we have to have the muscle. What I'm here to argue as a second speaker is that once we stop them with muscle, not through legal means saying we will punish you, we have to have the muscle to be able to get these people and prosecute them. And the International Criminal Court that was established in Rome does not have this muscle. It has no authority over any body of coercion to enforce what it has to do.
Information.
No, thank you. Now, there are many problems with this with International Criminal Court. On the one hand, it is extremely politicized and impartial. The opposition said that it is not, because the Security Council cannot just say, we will prosecute here and here, because it needs the full consensus of the Security Council, which are 5 countries. And it is true, it may be harder for the Security Council to decide which countries to prosecute. But it is very easy to stop the prosecution of a country. It is very easy to say, no, this country, leave it alone. Let's not meddle in this one. With just one country saying no, the International Criminal Court cannot act in that country. It has, no, thank you. It has to stop the prosecution. We are allowing justice to be subdued to political interests. This is not possible. Our main preoccupation here does not have to be politics. It has to be stopping these heinous crimes. Now, let me point something out. The International Criminal Court will work on the principle of complementarity. What this basically means is that if a country wishes to prosecute its own criminals, it can do so. However, if the International Criminal Court esteems that this country is neither able nor willing to truly provide a fair trial to these crimes, then it has the authority to take matters into its own hands. But let me point something out to you. It has no way of enforcing this authority. It's as if it didn't even exist. Because by following the principle of complementarity, we can obviously see that the only times in which the International Criminal Court will enter action, wait a minute, is when the country is neither willing nor able to act. So, the International Criminal Court will be acting without the cooperation of the government or the powerful groups in a country. Yes?
Complementarity allows for national sovereignty, and when a country wants to give up their sovereignty for the interest of the court to step in, the court has that power to work.
Yes, thank you. But if a country is able to prosecute its own people, then it will. And if a country is not able or not willing, it is simply because these criminals are either in power and therefore say, no, don't prosecute me, or they're tightly related to the power and the powerful groups, and the powerful groups say, no, don't prosecute me. So then the criminal, no thank you. So then the criminal court would say, well, we have to do it, we have to step in because this country is not willing or not able to prosecute these criminals. But here it comes into importance the fact that it does not have any real muscle. And this is really important because it cannot do anything. We've already established that when the criminal court comes into action, it's because the country does not want to cooperate. Fine. It does not want to cooperate, so we have a criminal court which cannot have access to files of relevance. It cannot have access to the evidence. We have a very obvious precedent in Kosovo a couple of weeks ago when the Serbian government, simply did not give visa to the investigators of the criminal court so it could have time to hide the evidence of the murder of 45 people of Albanian origin. This can happen simply because, no thank you, it happens simply because the criminal court does not have the muscle to go in and find out and enforce its decisions. But most importantly, I'd like to point out that the criminal court also works on the principle of that it can't prosecute anyone in absentia. What this means is that if you can't actually catch the criminal, if you don't have the criminal in the courtroom, you can't try him. Now this is on the principle that if he's not there, he would not be able to defend himself, and thus it would not be a fair trial. So yes, it would mean that the criminal court is furthering the cause of innocence until proven guilty. But it is also furthering the cause that you're innocent until you're caught. And ladies and gentlemen, because the criminal court does not have any muscle to go into a country and grab that person, he can run loose forever and ever. Two very simple cases are the cases of Mladic and Kradic, the two former heads of the Serbian government, which performed all these crimes during the Civil War. because the Serbian government does not cooperate with the criminal court, these criminals are at large. So the real people, the people that have to be tried, can't be caught because the criminal court does not have the muscle. It's just a vague institution which can do nothing. It's helpless. Its hands are tied. It does not work. Ladies and gentlemen, we've proven to you that the International Criminal Court has two goals. One is to try deterrence. This it cannot do. The people who do these crimes are fanatics. They cannot be deterred. They always believe that their cause is above any law. So what is the use of putting a law to deter them? They cannot be deterred. And in order to punish them, you would actually first need to get them. You would have to be able to get the evidence. And the criminal court, as it is established under the Rome Statute, does not have this force. And therefore, it cannot adequately punish them. It does not, it cannot comply with its two main goals, and therefore, it doesn't work. Thank you.
This House believes that the International Criminal Court won't work. Now, as the opposition, it is our duty to oppose the case of the proposition, so let's get down to business, let's do exactly that, and cast doubt on their case. Now, the second speaker has been talking about, the entire case has been talking about how the ICC lacks the muscle, how it lacks the power to go in and stamp itself on people and say, give me everything I want. But ladies and gentlemen, that is an inherent assumption in their case, that the ICC has to be something like Interpol, that the ICC has to be something of a standing army or a police force that goes in to seize evidence. Her examples of Bosnia reveal exactly that. She says that the ICC has no muscle, has no power to go in and seize evidence for itself. Her first speaker said that the ICC cannot go and stop the genocide and the slaughter, ladies and gentlemen. So therefore we see that in their arguments they have this fallacious assumption that the ICC, in order for it to work, that their criteria for it to work must be that it has to be a standing army, something of an Interpol or a world army that goes in to stamp itself on people. But we have told you that the ICC is a court, exactly that, what its name suggests. It is a court and is supposed to judge, ladies and gentlemen, to serve as an effective deterrent. No thank you, sir. And still on this idea of muscle, ladies and gentlemen, the second speaker continually asserts that the International Criminal Court has no muscle to enforce, has no ability to bring about cooperation or effective deterrence. But she never once ever referred to the exact specifications of the ICC to prove why this is so. And let me go on to show you how these have been complete fallacious assertions. In fact, she says when there's a mad dictator or fanatic in place, there's nothing a country can do. This is entirely wrong, because we see that cases can be referred to the ICC, first of all, by state parties to the Rome Statute, secondly, by state parties where the person has perpetrated a crime, and thirdly, where the Security Council itself can externally refer cases to the prosecutor as well as the court. No thank you, sir. So we see that her complete assumption and assertion that no one can refer a case to the ICC, no one can prosecute a mad dictator in place, simply does not work because of such mechanisms like allowing for the Security Council to refer cases, as well as forgetting that the independent prosecutor also can start investigations subject to approval by the court. No, thank you, sir. We also see that when she asserts there is no political cooperation, she forgets that 120 countries signed the Rome Statute, opposed to 7 that did not. So where is this lack of political will she is talking about? Furthermore, no, thank you, sir. Article 86 of the Rome Statute binds countries to cooperate, to hand criminals over, ladies and gentlemen, to cooperate and assist prosecution of the court. So again, where do we see this lack of so-called muscle that they are talking about? Secondly, ladies and gentlemen, she also talks about the idea of no cooperation and no evidence. Again, I've dealt with this in a fallacious example, but let me talk about this more. She assumes, ladies and gentlemen, that the International Criminal Court has to be a panacea and cause all countries to immediately roll over and give up their sovereignty and say, we will immediately let you trespass our borders come into play. But we have told you that the ICC is so effective. Why? Because it strikes this careful balance between complementarity as well as sovereignty, ladies and gentlemen. And this is one of the key reasons which our first speaker, I beg your pardon, has said why the ICC will work. Let me remind you then, on this point, that the first speaker has never at once dealt with our case, has never at all talked about why the ICC does not have a comprehensive scope, why the scope of the ICC will prevent it from working. She has never at all tried to rebut our points, ladies and gentlemen, except the point of complementarity, which we have already said is striking a careful balance between sovereignty and complementarity. So therefore, no, yes sir.
Yes, the point is that even though it might have a viable structure, if it cannot fulfill its objectives,
So
as
now,
we show,
sir,
it will not
now
work.
you're conceding that it has a viable structure, but again, in the same breath, you assert that it cannot complete its objectives. We have proven, we have cast doubt on your assertion that it cannot complete its objectives, and we have shown you that because of its viable structure, because of its comprehensive scope, because it allows for a careful balance between sovereignty and complementarity, because it strikes the root of the problem. All these things are part of its viable framework, which says why it will work. You have never tried to disprove this. Now moving on to my case, ladies and gentlemen, where I will prove to you that the ICC will indeed work because of the extensive framework of checks and balances. The fact is, the court is practical. It preempts future possible complications. And coupled with the political will that we have already established, we see it will indeed work. What are these checks and balances? Firstly, ensuring the impartiality of the court. Now the proposition has tried to assert that the court will not be impartial, but we tell you that this element of impartiality that is crucial in a court of law is there, ladies and gentlemen, in the office of the prosecutor. We see that the prosecutor is an independent, no madam, independent individual, not controlled by any particular country serving on a full-time basis. Article 42 provides for this, saying that the prosecutor shall not accept instructions from any external sources. We also see that the 18 court judges in the court are each appointed from different, elected and voted in from different countries. That means they're not just appointed, but they are voted in by a majority vote of participating countries. So we see that the ICC sets up an independent prosecutor's office to serve as a check on any possible vested interest that might come into play. The prosecutor can initiate investigations on its own. This means heinous crimes like Saddam Hussein's gassing of the Kurds can be investigated and prosecuted, no madam, whereas in the past, no one was willing to challenge Iraq openly. Secondly, we see in preventing exploitation and manipulation. We see that in the real world, vested interests often come into play, and because the ICC is tied into the United Nations Security Council, it might have hampered the effectiveness of the court. However, we also see that in a strange twist of fate, such things like the Singapore Compromise and the ICC also allow that the Security Council can only delay an investigation for up to 1 year. And that is only if you have unanimous agreement and vote of 5 permanent members. No, sir. You also see that this must be renewed annually. This means it is possible to prevent vested interests from coming to play, from blocking the effectiveness of the court, ladies and gentlemen. Lastly, we see continuous checks of the ICC to prevent loopholes and obsolescence. We see that checks and balances of the court include the annual auditing of the finances of the court to prevent the same wastage of resources that they assert happened in Rwanda, to prevent the same wastage of resources in the UN itself. We also see that the ICC will be continually reviewed to make sure it is up to date and applicable, beginning with a review 7 years after its entry into force. So wrapping up, ladies and gentlemen, we see that all these numerous safeguards, these checks and balances, the presence of such checks and balances reduces loopholes, such as the prosecutor's office, such as things like the Singapore Compromise, such as annual auditing. All these come together and culminate, ladies and gentlemen, in the viable framework of the International Criminal Court, coupled with its already comprehensive scope that our first speaker has pointed out to you, that it allows to tackle the root of the problem, ladies and gentlemen, as well as allowing for a careful balance between sovereignty and complementarity. Such measures serve as a viable framework of the court, explaining why the motion must not stand. The ICC will indeed work.
Thank you very much. The government today has based its case on 2 premises. One, that the court will have no power to deter these crimes, and secondly, that this court does not have a structure that enables it to punish the people who commit them. Why? Because it does not have complete jurisdiction over all the relevant area, because it remains a political tool, and because it lacks muscle. Now, the opposition today has countered this with 3 or 4 different premises. Firstly, and this I will dismiss lightly, that we have set too high expectations on this court. We did not, the opposition seems to believe that we want the court to be a panacea, and they have said that we can't expect it to work at once. What we are saying is not that the court will not be a panacea, is that it will not work properly. And this is what we're saying. It will not just not be a panacea, it will simply not work. By misrepresenting our case, they have ignored our argument. They have also said that the court lacks a comprehensive structure, and I will prove why this is not the case. And they have said how the court strikes a careful balance, and I will show how this careful balance, no thank you, is not careful at all, and it leaves a wide way for political speculation. They have also said that the court does well by addressing only the main offenders. To this I say that this is not right, because it means giving up on having comprehensive justice. It means just going for a few people who perhaps will be the politically most salient people, but it will not give comprehensive justice to everybody who commits these crimes against humanity, who are terrible, no matter whether you're a soldier, a lieutenant, or the president of the country. Now, on the issue of whether in principle these legal proceedings may deter criminals, we have said that these crimes are beyond usual considerations. The opposition has responded by saying that many of the people who perpetrate crimes against humanity are extremely bright. Yes, we do not question their IQ. We do not question that they can mount complex political systems that do atrocious things. What we're saying is that it needs a very distorted worldview to go and kill whole populations, to kill millions of people, to eliminate cultures. People like Pol Pot cannot be called balanced individuals who will weigh rationally whether there is a sufficient threat for them not to go and exterminate populations. These considerations are far beyond what the people who perpetrate crimes against humanity consider. They do not balance exactly the risk of whether they might face...
Point of information, sir.
Yes, please.
On the other hand, people like Pinochet's actions are very calculated and very rationally done in order to keep him in power.
I would like to call that simply wrong. The actions of Pinochet in Chile cannot be called balanced and rational. It meant killing the whole people just because of their political view. I do not think, no thank you. I do not think that we can call this balanced, calculated and rational.
Point of information.
No thank you. It needs a very distorted worldview to believe that just because people have different political ideals, they must be killed. They were called a disease in Chile and in Argentina. People who believed in communism were a disease. They had to be killed. Their children had to be killed. Is this a balanced act? Is this a calculated act? I say no. It needs a very distorted worldview to mount these political systems that perpetrate crimes against humanity. And for these people, it goes beyond mere calculations of whether they might have to face trial. The possibility of a far-off trial by far-off judges in a far-off international context simply does not enter the calculations of these people.
Point of information,
no, thank you. Now, on the issue of whether this court will have jurisdiction, this court, what it does is it goes and asks criminals, do you want us to investigate? If the country does not sign the treaty, and if the country has an ally in the Security Council, which is quite frequent, for example, Turkey, who has been accused of human rights violation, is an ally of the West, and it is just enough for this country not to sign the treaty and to have an ally in the Security Council, and they are free. They are off the hook. The court cannot touch them.
Point of information,
no, thank you. The countries like Turkey, like Israel, who have allies in the Security Council, are forever outside the jurisdiction of the court. The opposition has conceded that the structure of the court leaves wide way for national jurisdiction. What does the principle of complementarity mean? It means that the court can only act if the country is unwilling to prosecute these criminals. However, by the very way this court is set up, this court, in order to act, depends on the goodwill of the country where these crimes are committed. Because it depends on them to go and look for these criminals, to go and hand them over, to go and extradite them. How can a court that depends on the goodwill of these countries be working only in cases when these countries are unwilling to hand over criminals, to take the case for themselves? It is a contradiction in the very structure of their court. To this they have said that there is global consensus that this court has to work. They pointed to a vote that went 120 to 7. Firstly, this ignores that 21 countries abstained from voting. It was not simply a case of 94%. There were 21 abstentions. And secondly, who voted against the treaty?
Sir.
Yes, please.
Now, the fact is the UN Security Council, as well as the independent prosecutor, can still choose to prosecute criminals in non-signatory countries.
No, not in the Security Council. There is one country who votes against this. If there is one country in the Security Council, and there are 5 of them, with one saying no, this is enough. And secondly, I was talking about a completely different thing, which is that who are the countries that voted against this treaty? It is countries like China, countries like Libya, Iraq, the United States. These are countries that are leaders of the most powerful centers of power in the world. The United States, China, they are 40% of the Security Council. They account for almost 1/3 of the world population, and they are the most powerful countries in the world. There is not this global will and global consensus that this court has to work. There is great opposition to this court. It is not that suddenly we have all said, let's have this court work. No, this court has significant impediments to its working, and the opposition chooses to ignore them. We have also proven that this court will remain a political force. The opposition has pointed out that the fact that the Security Council needs 5 votes to block the prosecution of a certain individual means it's apolitical. We say the contrary. We say that with the fact that 1 vote is enough to block prosecutions of non-signatory individuals means that political consideration will be heavy, because as long as this country trades with the United States or trades with France, France will have a great interest in blocking his prosecution. They have said that yes, but the prosecutor will be impartial. But the prosecutor still depends on the political will of the countries involved. The Singapore Compromise, which the opposition mentioned, is exactly a compromise. It means allowing for political interference. It means allowing for political delaying of this court's action for renewable 12-month periods, which can be renewed ad nauseum. It means that justice again becomes a bargaining chip in peace negotiations, and this cannot be allowed for. It means that we are condoning to say, no, we'll postpone justice, we'll leave justice out for 12 months every time, instead of going for justice inflexibly, which is the role of a court. And this court will not have muscle. The opposition said, what do we want it? To have an army, to have a police? Well, courts in most places, they have authority over the police. They can issue search warrants. They have authority over people who have guns and handcuffs and search warrants. They have power to enforce these decisions. This court cannot try people in absentia. It just depends on the political will of countries. It depends on a consensus that it does not have. And it cannot deter the crimes that it is supposed to. So there are simply no provisions for the effective working of this court. Thank you.
Of the House. Now, as the affirmative in the debate today, and because we are in a debate, it is their duty to address our issues and our major contentions we have brought up. And I'm sad to say that at the end of today's debate, they have failed to deal with our substantive cases. They failed to explain to us why, when we told you about the scope of the ICC, when we told you about the checks and balances within the ICC, when we told you about the viable framework that is created within all of these provisions, why these will mean that the ICC will still not work. Now, all they could manage to do was to concede the point in the point of information and say that yes, even if you have the viable framework, unfortunately, you still won't have enforcement. So we see today an affirmative that cannot deal with our case. Now, having said that, however, let's now deal very systematically and very thoroughly with all the points that the affirmative has brought up. We shall do this in 4 major areas. The first I'd like to take a look at is the nature of the criminal. Secondly, I'd like to take a look at the whole principle of enforcement. Thirdly, I'd like to take a look at the structural faults within the ICC. And lastly, the whole issue of complementarity. So let's take a look, and let's begin with the issue of the nature of criminals. Now, they would have us believe that every criminal who commits such crimes are therefore fanatics and are irrational. And we tell you, first of all, even if this was true, and I say if because I'm going to deal with it later, even if this was true, they are therefore arguing against the very principle of any legal system. They are saying that any legal system cannot deter any criminal because any criminal is irrational. And we say this is unfair. They are not talking about the International Criminal Court per se. Now I said if just now because now I'm going to point out that people like Augusto Pinochet in Chile are in fact very rational. They are in fact very calculated, and they killed a lot of people, but that was for a reason. That was for a calculated reason in order to keep himself in power. People like Muammar Gaddafi of Libya sanctioned state terrorism, but because he wants to lift sanctions on Libya, no thank you, what he did was to expel a known terrorist. So we see that all these decisions are signs of a very rational mind. So first of all, I say that in this argument, the proposition is squirreling the motion. But secondly, even taking them on their grounds, they are wrong. And such criminals are rational, and they will be deterred by the International Criminal Court, because the International Criminal Court ends their cycle of impunity. Yes, sir?
How did the babies that Pinochet killed threaten his position in power?
No, sir. That is not the point. You're trying to sidetrack the debate. Again, what we have pointed out to you time and time again, without using emotive rhetoric, without reducing ourselves to the level of talking about killing babies, is that these things don't matter. These people are very rational in their actions, and you cannot say that simply because they are criminals, simply because they kill a lot of people, that means that they will not be deterred by an international court that comes after them. And this brings me to my next point, which is that about enforcement. And the proposition has made a big deal about this when saying the international court has no muscle. Now the point is, we agree that the court needs some muscle, but where we differ is when the proposition's demands become unreasonable, when they start telling us that the international court needs to be able to go in and grab someone, when the international court needs an armed force, which is what the first speaker said. And we say that this is very unreasonable, because the International Criminal Court, as an institution of justice and international law, cannot then violate the very principles of law it is meant to uphold. So having said that, however, we have pointed out Article 86, and I'll reiterate that Article 86 commits countries to cooperate fully with the ICC. And in case it doesn't, what it does is that the states are empowered to lodge a complaint of non-compliance to the General Assembly as well as the UN Security Council. So that is the enforcement mechanism that they are talking about. Now, furthermore, the more fallacious assumption is that there isn't any political will. And this became a big deal only in the third speaker when he tells us that people will not want it to work. But this is a contradiction on the first speaker who recognized that everybody now wishes the ICC to work, because everybody recognizes that the egregious crimes of genocide, of crimes against humanity and war crimes must be dealt with. And we tell you this is precisely why the International Criminal Court, from the Geneva Convention, all the way to the ad hoc tribunals, all the way to the Genocide Convention, and then finally to the International Criminal Court. That is why you get a 94% vote for the court. Now they again expect us to show that everybody voted for the court, and we say this is unfair. We say 7 people voted against. No thank you, sir. But among some of the people that did were Rwanda and Bosnia, the very countries that most of the examples came from. So we say that in this case, really, they do not have a leg to stand upon. The fact is, for the first time, the world is coming together in recognition of the need for a court. And that is why there's political will, that is why enforcement will take place, but even if it doesn't, we tell you that the court's Article 86 commits countries to enforcement. No, thank you. Let's take a look at the third issue, which is the whole idea of structural fault. Now again, they're being slightly unreasonable when they say that not everybody is under the jurisdiction of the ICC. Now, by implication, therefore, they are asking us to prove that everybody will be under the jurisdiction of the ICC. And we say, this is not fair. The ICC was set up only to try the most heinous crimes, not every crime. Now, the point is, they tell us, and this again only became a big issue in the third speaker, when he talked about political interest, when he talked about vested interest and the political tool. Now, between the first and second speakers, they have only asserted that this will happen. Now, only the third speaker did he come up here and explain that when you have one ally in the Security Council, that would mean that you would therefore get off the hook. Now, we say that this is not true. We say that independent prosecutor can initiate, he has the discretionary powers to initiate complaints without the referral of a state. And we say that this is very important, just a moment, sir, in countries such as Iraq and in countries such as Cambodia, because the independent prosecutor can therefore bring the attentions of such crimes to the court, which would not otherwise have been done so. Yes?
With one vote from the Security Council, this process can be stopped.
No, madam, you're wrong. This is where you're wrong about the Singapore Compromise. Now, the fact is, we have explained to you very carefully about the Singapore Compromise. Let me do it again. Previously, no, thank you. Previously, any member of the Security Council could veto the docket of the court by saying, no, you cannot go into this case. Now, one member could do that. Now, with the Singapore Compromise, although it is called a compromise, although it is called that, the fact is that now you need all 5 members in order to stop the court's procedures. Therefore, we say, no thank you, we say that this is a landmark victory. This proves to us that vested interest is not going to take place. Now, would you rather have that, or would you rather any security member being able to stop the whole court? And we say that these provisions, again, form the viable framework which makes the ICC going to work. No thank you. And again, the issue is about complementarity. And they tell us that it is easy to set up barriers within countries. And we say again this is not true because it assumes a lack of political will. And we say that complementarity as an issue is extremely important. And important in areas such as Rwanda, where the national court system has broken down. And therefore you need the international court to come in and to help the Rwandans set up a legal system. It is important therefore, while balancing the need for sovereignty and therefore creating a viable framework in order for the ICC to work. Now, rounding up on the side of the affirmative today, they have given us a rather weak case. In fact, they have set up their criteria as twofold, deterrence and fairness. But as the debate progressed, all they have concentrated on was deterrence, and they have failed to show why the ICC doesn't fulfill the second criteria of justice and fairness, which their first speaker themselves set up. Furthermore, we have seen that the case is shifting. We have seen that the case really only develops in the third speaker, and even then I've shown you that it cannot hold. Now, on the other side, on the negative today, we've explained to you concisely, because of the viable framework, the holistic viable framework within the ICC, the International Criminal Court will work.
Ladies and gentlemen, a very good afternoon once again. Now, at the end of today's debate, what have we seen in the course of today's action? Now, there are 4 main issues that I would like to bring up. Firstly, that of deterrence. Secondly, that of muscle. The third, the idea of the scope of the ICC. And the last, fourthly, the vested interest point. Now, ladies and gentlemen, beginning then with the whole point about deterrence, where today we saw that the proposition made a fallacious argument that all people who commit crimes against humanity, who kill others, must all be fanatic psychopaths, and therefore they can't be deterred. But ladies and gentlemen, as a team today, we have already proven that they were arguing against the principle of all courts in the world, all legal judiciary systems were useless, ladies and gentlemen, and not particularly the ICC. Ladies and gentlemen, we also refuted them by telling them that these were very extreme, polarized assertions that they made because criminals actually know rationally the weight of their actions. And ladies and gentlemen, the fact is, on our side of the house, we have indeed shown that deterrence is achieved, ladies and gentlemen, because the ICC targets the root of the problem. It targets the real perpetrators, the one who sent the command down the line, ladies and gentlemen, and therefore the court will actually break it where it counts. Deterrence will indeed be achieved, contrary to what they say. Now, secondly, ladies and gentlemen, was the whole idea of muscle, where they actually had the expectation, the unreasonable expectation, that the ICC must actually enforce law and apprehend criminals on top of being a court. So what they actually want the court to be is a 2-in-1 magical potion. What they actually want the court to be at the same time is a standing army. But ladies and gentlemen, we cannot expect the court today to be a global policeman, because as they as a proposition have already established, that is not in keeping with the aims that they themselves set out. Now, the ICC is merely a judicial court according to its own aims to deter, to provide punishment, sentences, ladies and gentlemen. So today, the affirmative simply cannot superimpose duties that they think the court should fulfill. They cannot superimpose these duties on the court itself. Now, ladies and gentlemen, let us move then to the scope argument, ladies and gentlemen, where they told us that structurally the ICC was flawed because it hasn't included enough countries. But the fact is, they have already established that countries do support, do see the desirability and do approve of the court, as seen by 120 countries voting in favor for it. Might I remind you, without reservations, might I remind you again, a 94% approval rate. Now, the point is, non-signatory countries can still be targeted because the independent prosecutor, the UN Security Council, actually allows for the targeting of non-signatory countries as well. And therefore, in the scope of the ICC, in the range of targeting of crimes against humanity, ladies and gentlemen, we see that the scope is comprehensive to deal with this. Now, lastly, ladies and gentlemen, the fourth issue of vested interest, where they told us that vested interest, political interest, can actually play a part. Now our second speaker's whole substantive case actually impacted on their claim, because he showed you, ladies and gentlemen, very clearly the checks and balances within the ICC, ladies and gentlemen, that the ICC actually allowed for. He showed you how it made provisions for impartiality because it has an independent prosecutor, because the judges, ladies and gentlemen, were actually elected. And ladies and gentlemen, he also showed you how exploitation could be decreased, how there could be no vested interest, because all 5 countries at the same time need to vote in order to prosecute a country. And he also showed you other checks and balances on the court itself, such as the financial auditing that goes on within it, to make sure, ladies and gentlemen, it is free from bureaucracy and corruption. And therefore, rounding up these 4 issues, ladies and gentlemen, we can clearly see that the affirmative today has failed to do with certain of our points, such as that of its comprehensive scope. And therefore, rounding up again, we see that the scope of the ICC is comprehensive because it targets the root of the problem and makes provisions for future eventualities. The court also makes room for checks and balances, and therefore, as a team, we have proven, because it has such a viable framework, it will indeed work.
Ladies and gentlemen, the issue in this debate today is whether or not the International Criminal Court can fulfill its objectives. It is the objective of any court, and not only the International Criminal Court, to deter and punish criminals. And as the government has proposed today, the International Criminal Court cannot deter and cannot punish these criminals. Now today, the arguments presented by the government have not been successfully challenged by today's opposition, as we will get on to see. And the opposition themselves, in their substantive case, in all of their arguments, have avoided the real issue in this debate. They have dodged it, and we have also dealt with their arguments. Now, the opposition today has had 3 main arguments in saying that the International Criminal Court will work. That first of all, it has a viable framework and a viable structure. Second, that there is a general goodwill towards the functioning of the court, which will therefore allow it to enforce its decisions. And finally, that the checks and balances allow for the proper functioning of the court. Now let's take a look at these one by one. The argument of the viable framework. First of all, the opposition is not looking at the real issue. Even if there were a viable framework, this is not of relevance, because the inability to deter and punish crimes will not let the court work. No matter how viable its framework is, if it cannot fulfill the basic objectives of a court, it cannot work. Not only as an international court, but as a regular court. And because the opposition has not effectively challenged our argument that it cannot deter and punish criminals, as I will go on to show, the whole argument becomes a blanket statement, because they are not looking at the real issue here. Can the court fulfill its objectives? And we today have shown that it cannot. The opposition has not dealt with our case. Now, as for the argument that 120 countries signed the treaty, therefore there is goodwill and it will work. First of all, therefore, 7 countries who didn't sign the treaty, okay, and there are 20 who did not, who abstained. And of the 7 countries that didn't sign, we include the United States and China, which are Security Council members. This is two countries in the Security Council which can block decisions which they don't wish to happen. And because they are opposed to the court, they will block decisions benefit them. There will not be general goodwill and cooperation towards the court because these decisions can be blocked, and we will not be pursuing justice and punishing criminals. And as for the argument of checks and balances, let me just dismiss it by saying that the opposition again is not looking at the real issue. So what if the International Criminal Court balances its expenses and regularly audits its taxes, as the opposition said? This is not of relevance here. The relevance is, even if it has a viable framework, even if it does audit its taxes, can it fulfill its objectives, ladies and gentlemen? No, it cannot. And today we have based our case on 2 contentions. That 1, it does not punish criminals, and 2, that it does not deter criminals. First of all, we have said that a rational, positive law does not deter criminals. That the standard approach to these crimes, as adopted by the International Criminal Court, would be ineffective. And this has not been challenged by the opposition. They have not shown why rational law does deter people. And the exceptional nature of these crimes requires a different approach, not provided by the International Criminal Court. Furthermore, on the idea that it does not punish, we have said that 1, that it does not have jurisdiction over all criminals of these kinds because, first of all, the Security Council can block their decisions. And today, the opposition has failed to show us how the International Criminal Court can deal with the Security Council veto. They have not showed us this. We have also said that the pursuit of justice cannot be achieved because of political interference. And political interference because two of the countries who are opposed to it are in the Security Council and can block these decisions. And the Singapore Compromise only applies to countries who have signed and ratified the treaty. And furthermore, because there is no way to enforce these decisions, the International Criminal Court might want to prosecute a criminal, but without some way to bring him to the trial, they won't be able to try him. They won't be able to put him in jail as they should, ladies and gentlemen. And so because the opposition's arguments avoided the issue and our own case, and because our arguments have remained intact and have not been successfully contended by the opposition, the motion must stand. There is simply no effective provisions to deter and punish these crimes by the International Criminal Court. Thank you.